Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, May 30th, 2019. The time is 9:00 a.m. and we are meeting in the Hearing Board room in Diamond Bar. We have one matter on the calendar for this morning, and that is Amoresco Chiquita Energy LLC, case number 6143-1 for an interim variance. And who is representing Amoresco Chiquita Energy today?
And good morning. My name is Andrew McClelland. I'm an environmental compliance specialist for Amoresco Inc., which owns and operates Amoresco Chiquita Canyon, LLC.
Thank you. And can you just restate your name for the record and spell it for us?
Sure. It's Andrew, A-N-D-R-E-W. Last name is McClelland, M-C-C-L-E-L-L-A-N-D.
Okay. And you are, just if you could just repeat one more time, your title and who are you with?
Okay, so I'm an environmental compliance specialist. I work for Amoresco Inc., which owns and operates Amoresco Chiquita Canyon, LLC.
So the parent.
Correct.
Okay. Thank you very much. And who is representing the executive officer this morning?
Good morning. Mary Reichert on behalf of the executive officer.
Good morning. Before we begin, I assume you have not been before us before, Mr. McClellan?
That's correct.
Okay. Have you had an opportunity at all to view, we have a video on how this will go, how the proceedings go. Have you had an opportunity?
I did.
Okay. Probably, though, I don't believe it includes the bifurcated hearing that we have when we have an interim or an emergency variance. So you're probably not familiar with that, are you?
No, Mary explained it to me a little bit, but having never been through it before. No.
Okay. Well, I'll just take a couple minutes and just explain to you so you understand how we're going to proceed today. So for an interim variance, obviously it is of an emergency nature, and so we don't have time or ability to give notice to the public as we are required to do for all of our hearings. So in order to do that, we bifurcate the hearing, and we first have a hearing to determine whether there is good cause to proceed in absence of notice to the public. So it's similar in what we have to find, but there's some additional findings, and they're somewhat different from what we need for the actual variance. And if we can find good cause, we'll proceed to that immediately after. But I'll just let you know quickly what those findings are. We need to know that you are in violation or imminent violation of some rule or regulation. You'll need to show us evidence that the circumstances that led to that violation could not reasonably have been avoided, very similar to the beyond reasonable control finding you'll have to make anyway. And then what's different is that you'll need to show us how you exercise diligence in coming to the board and petitioning for a variance as soon as you knew or should have known that it was more likely than not that a variance would be needed, and that a denial of a interim variance would result in some unreasonable and unavoidable adverse impact to you if you would have to wait until a noticed hearing is held. So when we'll help to prompt you. So the way that it'll work is I'm going to come to you if you'd like to give just a brief opening, which is just a brief summary of your position, and then I'll go to Ms. Reichert. She'll also give a brief opening for giving the position of the district on good cause. And then you can present whatever evidence you have in the form of testimony, or if you have additional documents, you can present them if you need to. And then Ms. Reichert will ask you questions, and so will the board members. And then we're going to deliberate on good cause, and if we can find good cause, we'll move forward into the variance hearing. And we have a lot of petitioners who come without counsel, so we can help through if you have any questions. But first, I'm going to begin by asking you and anyone else who might be giving testimony in today's hearing, including, well, there would be no members of the public, but to please rise to be sworn in at this time. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Mr. McClelland, if you'd like, you can give a brief opening statement.
Okay. As I said, I'm the environmental compliance specialist for Amoresco Inc., which owns and operates Amoresco Chiquita Canyon. We receive landfill gas from the Chiquita Canyon landfill, which we dewater, filter, and process through a temperature swing adsorption system, or TSA, prior to burning the gas in two 4.6 megawatt landfill gas-fueled turbine generators. The TSA system is designed to absorb contaminants called siloxanes from the landfill gas, which can cause premature engine wear. The TSA utilizes a bed of alumina-based adsorbent, which undergoes periodic regeneration by heating and purging with air. The waste gas from the regeneration cycle is sent to a 12.1 million BTU per hour flare, which also burns landfill gas to maintain temperature. Prior to this week, we relied solely on the conditions in our Title V permit to establish emissions testing and reporting requirements on the engines and flare. We believe that the emission testing requirements on the engines were due annually by May 31st, according to condition 20 of permits GT 25211 and GT 25212. Reports are due 60 days later. We believe that emissions testing on the flare was due within 45 days of the anniversary of the initial test, which was completed on April 15th, 2011, making the flare deadline May 30th, according to condition 10 of permit G23448. No reporting deadline is identified for the flare. This week, AQMD explained that the plan is subject to Rule 1150.1, which requires both emissions testing and reporting to be completed within 45 days of the anniversary of the initial source test. I have not been able to seek guidance from Ameresco's legal counsel on the applicability of the emissions testing provisions in Rule 1150.1, but we wish to proceed with the assumption that these requirements are applicable in order to continue operating and providing a source of renewable energy to Southern California. Rule 1150.1 testing and reporting requirements are more restrictive than our permit. According to the rule, Engine 1 testing and reporting is due by May 21st, Engine 2 testing and reporting is due by May 22nd, and flare testing and reporting is due by May 30th. We are unable to meet the deadline for emission testing on Engine 1 and the deadlines for reporting on Engines 1 and 2 and the flare. Testing was scheduled to begin on Engine 1 on Tuesday, May 21st, followed by Engine 2 on May 22nd, and the flare on May 23rd and 24th. The test ports on all units are accessed using a boom-type man lift. On the first day of the test, wind speeds monitored by the testing vendor exceeded 25 miles per hour at the test ports. According to their policy, use of a man lift is prohibited in wind speeds which exceed 25 miles per hour, so Engine 1 testing was postponed. They were able to successfully test Engine 2 on Wednesday, May 22nd, before the winds increased. Ameresco installed scaffolding on the flare on Wednesday to mitigate any wind issues, and flare testing was able to be completed on Thursday and Friday, May 23rd and 24th. We were unable to complete testing on Engine 1 prior to the May 21st deadline, and we are unable to meet the reporting deadlines of May 21st, 22nd, and 30th for Engine 1, Engine 2, and the flare, respectively. We submitted our petition for a variance on Wednesday, May 22nd, the day after learning of the delay in testing Engine 1. We need to request an interim variance because there is not sufficient time for public notice prior to the Rule 1150.1 testing and reporting deadlines, which have already passed for the engines. The flare deadline is today. The delay in testing Engine 1 was due to high winds at the facility which were beyond our reasonable control. The delay in source test reporting was the result of our understanding that the Title V permit to operate was the only source of emissions testing requirements. We did not realize that Rule 1150.1 contains more stringent requirements that are not part of the Title V permit. If we do not receive a variance today, we will need to shut down the engines until Engine 1 testing can be completed and the source test reporting can be completed for all 3 units. While we don't expect to lay off any employees, the plant will lose approximately $10,000 of revenue per day during the shutdown. Assuming 45 days before we are in full compliance, that will be a loss of $450,000. Thank you.
Thank you. Just to clarify, so Engine 1 has not been tested to completion, and there's reporting that is still outstanding for Engine 2 and the flare?
Correct.
Okay. And I just, before I turn it over to Ms. Reichart for her opening, I just wanted to make sure you understand, we cannot give retroactive variance protection. So it would have to, anything we would grant would have to start today.
Understood.
Okay, thank you. Ms. Reichart, your opening.
Good morning. As petitioner has described, they seem to have been operating under an understanding of different deadlines for their source testing dates as well as their reporting dates. And based on the records that I was able to obtain through staff, I understand that since their initial tests in 2011, they have been testing and reporting pursuant to their understanding of those deadlines, and with no enforcement action otherwise on our part. As we reviewed this petition and looked into the requirements, we calculated the dates pursuant to 1150.1, which are noted. 1150.1 is referred to in several different locations in the permit, but the specific source testing dates and reporting deadlines are not individually identified in the permit, which is not unusual. Not all requirements are always reported, but in this case, they were not itemized in that section of the permit, but the permit does require compliance with 1150.1. We informed petitioner of those other dates, which basically just slightly changes the dates by which these items need to be completed, but still requires variance relief. It doesn't change their need for variance relief. And I'm not sure that it was clear, but I believe that petitioner wanted to also add in a request for relief from 1150.1, which was not specified on their petition initially. So I don't know at what point you want to handle that, but
Well, do you know, Ms. Reichart, offhand, which subsection?
yes. 1150.1, small d, 1, big C, I, and small f, 2, big A.
Well, we'll go on that quest in a moment.
So, based on the circumstances herein and what appeared to be the petitioner's good faith attempt to test pursuant to what they had been testing previously, and their quick action to file shortly after they were unable to test Engine 1 on May 21st, the district is not opposed to a finding of good cause.
Thank you. Mr. McClelland, we will accept your opening statement as testimony since I know you did take the oath this morning when I administered it. Do you have anything you'd like to add? Well, first of all, let me mark. We did have attached to the petition the particular pages of the permits, the 3 permits at issue, with the applicable permit conditions, but this morning we received fuller, I don't know if it's the full permit to operate for each, but certainly fuller versions. And so let's mark them since we have them. And I don't know, Ms. Reichart, did you also receive that? Okay. So let's mark permit number G25211, G25211 as Exhibit 1. And permit number G25212, 212 as Exhibit number 2. And finally, Exhibit G23448, which I believe is the flare, will be Exhibit number 3. And so we've heard testimony with regard to violation of rule regulation. If you wanted to add anything to the testing, why you picked the dates that you picked, what occurred, if you have anything else to add, and also what happened once the testing could not go forward in petitioning in terms of a timeline in petitioning the the board for a variance. If you have anything to add, this would be a good time.
Okay, is this part of the
This is the good cause.
good cause? Okay.
Mm-hmm.
I don't believe I have anything to add, no.
Okay, then we'll turn it over to questions.
Okay.
Ms. Reichart, do you have questions?
Yes, thank you. So I just want to walk through the timeline a little bit more specifically. Can you describe why the facility picked those dates in May to schedule the source testing for the two engines in the flare?
We typically choose a source test date around engine maintenance and the source test vendor's schedule. In this case, I believe it was the source test vendor's schedule that drove the test date selection.
The source test maintenance schedule, is that what?
Vendor.
Vendor schedule, I'm sorry. And so these were the dates in the month of May that they were available?
Correct.
Okay. And what were the initial dates that were set for each of the engines and the flare?
So the source testing there takes an entire week. Let's see, Monday, May 20th was the setup day for the test vendor to get their equipment. Engine 1 was to be tested on May 21st. Engine 2 was to be tested on May 22nd. And then the flare takes 2 days. So it was to be tested on May 23rd and 24th.
Okay. So engine 1 was unable to be completed on the 21st due to winds exceeding 25 miles per hour?
That's correct.
Okay. But on the 22nd, were the winds lower that day, or why were they able to complete testing of engine number 2?
The winds were less than 25 miles per hour in the morning. They were able to complete the portion of the testing that required them to be on the man lift
Okay.
before the winds picked up.
And why were they not able to also test engine 1 on that day?
The testing for an engine takes an entire day between the testing for the criteria pollutants and then the flow meter rata, or I'm sorry, the SEMS rata takes the entire day to complete.
And then the testing of the flare on the 23rd and 24th also takes those entire 2 days?
That's correct.
Okay. And the source testing company was unable to continue for an extra day to try to test engine 1?
We asked them to work night, weekend, and they were unable to do so.
So they were busy through at least the end of the month?
Yes, that's correct.
Did you contact any other testing companies?
We did. This gets into the plan for compliance, if you'd like me to.
Well, if you can just discuss just kind of why you were unable to quickly get these tests completed before the dates that you thought were your due dates, the end of May.
Our primary source test vendor was unable to return the following week, and we didn't have another option, another vendor on such short notice.
Okay. Were you just not aware of other vendors that could do it, or you hadn't researched them, or why were you unable to contact any other vendors at that time?
It was such short notice. At the time, we were pushing Arrows, our primary test vendor, to reschedule and come back the following week.
Okay.
We did reach out to another test vendor, and I can explain later, the other test vendor is taking over another facility that Arrows was supposed to do for us to free up Arrows to complete the test.
And Arrows is the test vendor you have
That's the
always
primary.
used, or?
Yes.
When you say primary, that means that's the one that you use every year?
They're the one we go to for Chiquita Canyon.
Okay. Have you ever used a different test company at Chiquita Canyon?
The initial test was done by URS in 2011. I don't know of another vendor that we've used since besides Arrows.
Okay. And you filed the petition on May 23rd, is that correct?
I believe I sent it on May 22nd. You must have received it on May 23rd. We overnighted it.
Okay.
That makes sense.
And so when did you first realize that you were going to need variance relief?
On May 21st, when we realized that we weren't going to be able to meet the testing deadline.
So that date, you realized they couldn't do that testing, there was not enough time in the rest of the week to complete all of the engine, or both of the engines and the flare, and they had already confirmed to you that they could not extend the time at your facility?
That's correct.
Okay. Can you just briefly describe what will happen to the landfill gas if if you are unable to operate the engines?
Yes, if we have to shut down our engines, the landfill will burn the gas in their flare.
Okay, so the gas will have to be burned because something has to happen to the gas, correct?
Right.
Right. And do you know the difference between, if any, between the emissions from flaring versus in the engines?
I can't speak to the emissions from the landfill's flare. I don't know, but our engines, NOx and CO were measured at sub 1 pound per hour.
Okay. And do you know what your flare is, just as a comparison of a flare?
Yeah, I do. Our flare during the last source test, just NOx and CO. NOx was 0.2 pounds per hour, CO was 0 pounds per hour.
Okay. But the difference when you have them in the engines is you're also producing energy, is that correct?
That's right.
Okay. I think that's all the questions I have. Thanks.
Thank you. Board members, questions on good cause? Ms. Byrd?
It appears that you're from out of state, is that correct?
Yes, ma'am.
So you just fly in to take care of this. Do you take care of this from out of state, when all of the management, or do you come here?
Yes, ma'am. I take care of most everything from out of state. Once or this year twice, I fly out to California to conduct site visits.
Okay. Have you ever had an experience where the winds were high before, when there was source testing scheduled?
At this facility last year, in late 2018, we had to retest the flare. And on one of those days, we had high winds, but we were able to complete the test, I believe, the following day.
Okay, so you were able to complete the test because the source test vendor was able to remain? Is that-
Correct.
Okay. Okay, thank you.
Mr. Balagopalan?
Yeah, Mr. McCallum, I'm trying to get the dates. So when is your anniversary date? When, in 2018, when are the tests due? When do you normally do the tests, and when is the due date, the annual due date for the tests?
So normally we do,
I know 1150 was thrown in right now, but just what was your understanding of, when it's due and when you were supposed to report?
our understanding was that the engines were due to be source tested by the end of May 31st. And the flare was due to be source tested by May 30th. And then the reports, we understood to be due 60 days after the test date.
And that's based on the permit conditions?
That's correct.
Can you cite those conditions where you see that?
That would be
Let's take Exhibit 1, that's for engine number 1?
Exhibit
Turbine
1.
number 1, yeah.
Exhibit 1 is going to be condition 20.
Okay. Anyway, it says annually conduct and submit within 60 days after testing.
That's correct.
So that's what you were going by,
That's correct.
the condition, okay. So May 30th. Okay, so you, by scheduling a week, so approximately a week earlier, you figured you'll be done and be able to meet those deadlines in the permits?
That's correct.
The flare, I mean, it's the platform you need for source testing. How high are the stacks for their 2 turbines?
I don't know how high.
Approximately,
Approximately 50 to 60 feet
Okay, so the man lift, it's dangerous for them to be up there at that high velocity.
in high
with-
winds. Correct.
The flare is at a much lower height, I take it?
Oh, I'm sorry, I thought you were, the engines, I'm sorry, I misunderstood. The engine test ports are 25 feet off the ground roughly, and the flare is probably 50 feet.
Oh, flares higher? than the-
Yes.
Okay.
Yeah.
But they were able to test the flare on the 30th because of the wind?
They were able to
Oh,
test.
no, on the 22nd and 23rd, right?
On the
23rd,
23rd.
24th,
Yes,
23rd,
yes, sir.
24th,
Yep.
sorry. So they
We-
tested,
We had scaffolding installed on the flare,
oh, I see, okay.
so they were able to complete testing.
And there's no scaffolding on the turbine stack?
There wasn't. There is now on engine one in preparation for testing on June 3rd and 4th.
So when is the earliest commitment you have got from Aero when they can do the test?
June 3rd and 4th.
June 3rd and 4th?
That's correct. June 3rd will be a setup day. June 4th will be the test day.
Now, and do you expect them also to take about 60 days before, to get the report?
We can push them to get us the report sooner than 60 days.
So the 45-day requirement in the rule, you could ask them to do that?
I believe we can have the test reports ready within 45 days of the test day. That's correct.
Actually, I didn't get that section of the rule you pointed, Mary, right? Do you mind, I'm sorry, do you know which section of the rule, 1150.1, that applies? Oh, I think I may.
I have some copies of the relevant sections of the rule, 1150.1, if you'd like them.
We have it, but I think, Ms. Reichart, you listed two sections?
I
Is that
did.
why it seemed like this very
Oh,
overwhelming?
I'm so sorry.
Okay.
I am so sorry I was not clear there.
D1C1 and then F2A, is that correct?
Yes, I'm
Okay.
sorry, that was not clear.
I think we were
You
both trying to
thought
unravel that at the
that
same
was
was all
like
one,
seven?
yeah.
Oh, my gosh.
I was like, what kind of rule is this?
Yeah, I know, it was like, where? Okay, so actually, let's look at D1C1, that's on page, let's see what it is.
He does have the individual
Oh,
sections,
individual
just like
section.
one
Now,
page
maybe
it looks
can-
like, if
yeah,
you
it might
want.
be easy if that's okay. Yeah,
I
Yeah,
know.
Sorry.
Yeah.
You
It's
did
like
just
very
offer that, and I said, no, thanks, but yeah, no, please.
oh, that's four. Oh, okay. Each one gets one, right? Yeah. One side, this the other side. Two separate.
I don't have to mark these because we have copies of the rule. I'm just going to make sure we all have it. Wait. Okay. So here's one of the rule sections and the other. Got it.
Can I just confirm what you're looking at, that it's, should at the bottom says 1150.1-6 and 1150.1-18?
Yes.
Yes.
I just want to make sure we're all looking at the same page. Thank you.
So on page 6, on the 1150.1-6, and that's C1, D1C1. So that says the annual test shall be conducted no later than 45 days after the anniversary of the initial source test, correct?
That's correct.
So that's not in your understanding that was in the permit?
That's correct. To our knowledge, that's not in the permit, no.
So let me just clarify again, when was the anniversary date then? When is the anniversary date of the initial source test?
The initial source test on engine one was April 6th.
Okay,
Engine two is April 7th. And the flare is April 15th.
but you have been traditionally conducting it in May, the test, is that correct?
Correct.
Not on the, so it's 45 after the anniversary date. Okay, so you still be okay. April, May after the anniversary. So if April 6th, the 45 days will put it in May mid-May then, right?
That would be, correct, May 21st for engine 1 and May 22nd for engine 2,
22nd, and the flare would be
May 30th.
May 30th. So you had scheduled it then correctly in the 45 days, it appears, right? To conduct the test.
Just barely,
Yeah.
yes.
Okay. Now, let's see the other, on page 18, which is on the other portion of it. This is when the report should be submitted, right? And that says 45 days to submit the report, is that correct?
That's correct.
Instead of the 60 days in the permit,
The permit says 60 days, that's
60
correct.
days. So were you aware of the requirements of 1150.1 dates in conflict with the permit conditions?
I wasn't aware of the conflict until this week. I wasn't aware of the deadline requirements in Rule 1150.1 until this week.
Was there any reference in your permit to it to 1150.1?
There are references to 1150.1 in the permit, but not in the emissions testing and reporting conditions.
Okay. Okay, thank you.
Senator, you have questions?
45 days from the initial testing. That is the new established deadline, which is May 21st, 22nd, et cetera. Now, my question is that, have you had this problem before?
We have not had a problem meeting the emissions testing deadlines, no, sir.
Have you measured the wind flow at any time when it's approaching the deadline? Any weather forecasts, which might interfere with the testing?
We weren't aware that the winds were going to be a problem for the source test vendor until the day of the testing.
How long has this landfill been in operation?
I don't know how long the landfill's been there. Our facility has been in operation since 2011.
2011. And this is the first time you had a problem like this?
Yes, sir. This is the first time we haven't been able to
To
meet
test.
to test before what we believed was our deadline.
When you have this company perform this test for you, do you ever use another company other than one that you mentioned here?
The initial test was done by URS,
You are.
but since I've been with Amoresco, I believe that only Eros has done the source testing for us at this facility.
And when they accepted the contract to perform the service, did they indicate any terms and conditions in the contract which suggest wind might be a problem, wind flow?
I'm not familiar with the contracts. I couldn't answer a question about that.
Anybody ever relate to you that flow could be a problem beyond 25 miles per hour registered?
We had a test in late October, or I believe it was in the fall of 2018, where high wind speeds delayed the test, but we were still able to meet the deadline.
Delayed the test.
Correct.
Okay, now, what happens when the flare is not in operation?
If our engines and flare aren't in operation, then the landfill will have to operate their flare.
Okay, what happens, does it cause any wear? It says here, landfill gas would accumulate in the engines and cause premature wear and failure.
If we can't operate the TSA flare, we can't operate that portion of the landfill gas treatment system, and we won't run the engines
What's
without.
what's the function of TSA flare?
The TSA flare controls contaminants from the regeneration of the TSA media.
And those contaminants have an adverse effect on the performance of the engines.
That's correct.
And you have a maintenance program scheduled there also, every 4,000 hours.
Every 4,000 hours is a semi-annual maintenance event, and I learned yesterday, speaking with the plant operator, that they also do a limited maintenance event every 3 months.
Have you discovered any adverse problems or effects as a result of the flare not performing efficiently?
I don't believe we ever operate the engines without the TSA in service and the TSA flare in
And
service.
TSA in service is working 100% of its expectation?
It is.
All right, thank you.
Welcome.
I'm still a little confused as to what the violations are. So, it's only engine number 1 that has not been tested as of today.
That's correct.
Okay. And then you are asking or not asking for relief from reporting requirements?
I am asking for relief from reporting requirements.
Okay. And can you just explain briefly why you need that relief?
We will not be able to meet the reporting deadlines in Rule 1150.1 for any of the emission units.
And that's because,
The reporting is due, the reporting and testing are both due 45 days after the anniversary, which
okay.
is this week.
And that was the May 21st, May 22nd, and May 30th?
That's correct, yes,
Okay.
ma'am.
Thank you. Now I'm perfectly clear. Okay, that's all my questions. Any other questions? Senator had a question.
When you anticipate putting back online the scheduling procedure, the testing procedure with this company being available, what days do they tell you they will be available to perform the test for engine 1?
They are available to test engine 1 on June 4th.
On June the 4th?
That's correct, yes,
And
sir.
therefore, you expect you'll be in compliance?
Yes, sir.
So you'll be in compliance, okay, all right, thank you.
That's with testing, correct?
Yes, ma'am.
But you still need a longer time for, well, though this is getting into the merits, but I do want to understand, when do you think you can have once that engine is tested, when can you have the results and reporting completed?
We will push Aeros to complete these test reports as soon as possible. I don't think it would be a problem for us to meet a deadline of July 7th, 2019 for engine 2 and the flare, and a deadline of July 19, 2019 for engine 1.
I'm sorry, say that date again?
July 19th for engine 1, and then July 7th for engine 2 and the flare.
Okay, thank you. Mr. Belagopalan, you had a question?
So the reporting deadline, July 7th, so that's how many days after the test has been conducted? Because it was, so it'll be within the 60 days, but not 45 days.
That's correct.
Okay. And it's 45 days from the date of testing, right? Well, you missed the anniversary date, yeah, okay. And is that the same company, Aero, that's coming back to test engine, turbine 1?
Yes, sir.
It is, okay. And in the past testing, have they demonstrated compliance with the rule limits as far as the thresholds that are established in the permit?
Yes, sir. The engines have, since I've been with Amoresco, the engines have met their emission limits.
Emission limit? Okay. All right, thank you.
Any other questions on good cause? Okay, thank you very much. Ms. Reichart, do you have any witnesses on good cause?
No.
Okay. I'll ask if you'd like to summarize any closing statement on good cause, Mr. McClellan.
No, ma'am.
Ms. Reichart? Any
Thank
closing
you.
statement?
As we've parsed out here, there's some confusing aspects to the deadlines and when things were due, and we even went back and forth trying to figure that out here. And as I mentioned in my opening, while the facility is required to comply with all of the requirements in 1150.1, it seems like they had an honest misunderstanding about the due dates. And therefore, I am not opposed to a finding of good cause. And I think that they have shown that they exercise diligence to try to meet the deadlines as they had previously understood them based on what is actually spelled out in the permit. Thank you.
Thank you. Board members, I think we can find good cause to proceed with a hearing on the merits in absence of notice to the public. As we've unraveled here, there are several rules and permit sections that petitioner currently is already in violation of. And that includes the 1150.1 reporting requirements, which passed on May 22nd, May 21st, May 22nd, and May 30th today, which they will not meet. And also, we've heard that engine 1 was not able to be tested because of high winds. I do believe that the circumstances leading to the violation could not reasonably have been avoided. Usually ignorance of, and I don't like to use that word, it sounds harsh, but not knowing about a rule or not understanding it is not an excuse. But I do think, as Ms. Reichart pointed out, I think in this case, I think it was an honest mistake, and I think that petitioner clearly will not make that mistake again next year. However, it is confusing, and the permit conditions which require the annual testing do not mention specifically 1150.1, and 1150.1 is hard to just kind of read and figure that out by yourself. But now we've unraveled that, so I do believe that it was honest and reasonable to not have realized that those requirements came before the testing dates and requirements in the actual permit. Now turning to the permit requirements, even though there were high wind conditions, engine 2 and the turbine were successfully tested. And so there's no issue with that. And engine 1 was tested on a high wind day. Since 2011, the testimony was the only other issue with high winds was in testing in 2018, which simply delayed the testing, but did not avoid or prohibit the testing. And so I believe that could not have reasonably been avoided or foreseen. Diligence in petitioning is clear. It was on the 21st that the high wind conditions occurred. According to the testimony of Mr. McClelland, it was the 22nd that the petition was completed and overnighted, and we can see from the stamp on the petition that it was actually filed on the 23rd. And I believe that denying this would be an unreasonable and unavoidable adverse impact because there would be losses from not being able to generate the power. It's not a better use of the landfill gas, which has to be burned either in a turbine or in a flare, and potential fines as well. And there should be no excess emissions. We haven't gone to that yet, but from what we've heard so far. So I think it would be unreasonable to have those kinds of adverse impacts to petitioner. Anybody else? Mr. Balagopalan?
Yeah, I agree. I think petitioner did in good faith schedule the test based on the understanding of when the due date is, and it was unforeseen that the high winds, and so they couldn't test the turbine number 1. And it's but they did test the second turbine and the flare. So they've completed the testing. And again, the reporting, the permit condition gave them a wrong date, indicated they had 60 days. Well, the rule is 45 days, so the rule is more stringent, so that should be the applicable standard. But they were unaware of it, and I think we had testimony of the district that this has been going on for a while, and compliance had not taken any action on it. So they were led to believe that this was acceptable, or, I mean, not acceptable, but they weren't aware of the conflicting dates in the rule and in the permit conditions. So I think, and I think they have already scheduled rescheduled the test for the turbine number 1, and that's happening June 3rd, 4th. So that will be done and completed. Hopefully, there won't be any winds on that day or to delay that. But it looks like they've erected some platform around the stack so they can safely be up there to do the test. So and then so I think on that basis, and I think it's if they don't have, if the turbines are not operating, and then it'll be a waste of resource of the to flare it out, because by burning it in the turbine you can recover and create electricity and recover the energy. So it's a waste of to flare it off. That's all I have.
Thank you. Anyone else wish to have further discussion on good cause? Senator.
I see it quite differently. 45 days after the initial test, years and prior thereto, was required in order to perform this test to certify these engines and flares, et cetera. And that was done for a number of years, adhering to the 45-day schedule. And here again, you made an attempt to do it in that time frame to be in compliance. But the wind said you had an overriding factor against that test taking place. So it's the wind. That was beyond your control, obviously. Did you make an attempt to be in compliance? Yes, you did. And inasmuch as the wind flared up at that time, the company performing the test could not hang around and wait for the wind to subside. And they had other jobs they had to perform according to your petition. And they performed those. They told you they could do this service, but schedule it at a later date when they're available and when the winds subside. And that's what you saying by giving us a time frame when you think that you can be tested and you will be in compliance. So yes, it's beyond your control because of the weather, in my view. Yes, there will be a loss of revenue, almost $600,000. I can understand that over a few months period of time. And of course, the service you provide would not otherwise be provided to the community that needs it most. So I would say that for that regard, yes, beyond control, yes, you met the requirements to hear the issue.
Thank you. Any other thoughts before I make a motion? Okay. I'm going to make a motion based on the discussion in the matter of Amoresco Chiquita Energy LLC, case number 6143-1. I move that we find good cause to proceed in absence of notice to the public with this interim variance hearing based on the findings and discussion we just had. Anyone wish to second that? Mohan, I'm sorry, Mr. Balagopalan. Seconds. Any discussion on the motion? Seeing none. Senator, how do you vote? Aye. Ms. Byrd, how do you vote?
Yes.
Mr. Balagopalan?
Yes.
I vote yes. Motion passes 4-0. Okay, so now we will move into the second part of the hearing, which will be the 6 findings. And as we had said when we started this good cause hearing portion, a lot of what the testimony we've already taken and the evidence we've already taken will apply to the 6 findings. And we do have to make a couple more findings as well. But let me just ask, I assume the answer is yes, but would you like to incorporate all of the evidence and testimony that we just heard into the second part of the proceeding?
Yes, ma'am.
Okay, and Ms. Reichart, no objection?
Correct.
Okay. Mr. McClelland, would you like to have an opening on the 6 findings for the variance? And in particular, perhaps you can give us more of a time frame. I see it's changed from the petition in terms of moving forward, so what you're looking for in terms of timing of relief. And I don't know, Madam Clerk, if we could flash on the screen those 6 findings that we have kind of split.
The opening statement I have here is the one that I have already read to you.
That's fine.
Okay.
Then what I'll do is I'll just turn to Ms. Reichart. Do you have any opening statement you wish to make on the merits?
Yes, thank you. Subject to the testimony presented here and compliance with the proposed conditions, which I will present, the district is not opposed to the granting of this variance. As you'll notice in the conditions that I'm going to present, the dates petitioner referred to during the good cause portion regarding reporting are set forth here in the conditions.
Thank you. Why don't we take a moment then before we start with questions and testimony and have that handed out. Okay, we've received proposed interim variance conditions, and we're going to mark those as Exhibit A as an apple. And just take a few moments just to read that before we begin. Okay, we're back on the record. Let's start, Mr. McClelland. Do you have any additional evidence you wish to add in terms of any of the additional findings? If not, we can always turn it over for questions.
I can address each one of the findings.
That would be helpful.
Okay. Finding number 1, we are seeking a variance to allow us to operate engine 1 in violation of Rule 1150.1, Section D1CI, by conducting emissions testing after the May 21st, 2019 deadline, and also a variance to allow us to operate in violation of Rule 1150.1, Section F2A, by submitting test reports after the deadlines of May 21st for engine 1, May 22nd for engine 2, and May 30th for the flare. In regards to finding number 2, the delay in testing engine 1 was due to high winds at the facility, which were beyond our reasonable control. The delay in source test reporting was a result of our understanding that the Title V permit to operate was the only source of emissions testing requirements. We did not realize that Rule 1150.1 contained more stringent requirements that are not part of our Title V permit. If we do not receive a variance today, we'll need to shut down the engines until engine 1 testing can be completed and source test reporting can be completed for all 3 units. We don't expect to lay off any employees, but the plant will lose approximately $10,000 of revenue per day during the shutdown. And that's assuming 45 days before we are in full compliance. The total loss will be approximately $450,000. In regards to finding number 3, there will be no benefit to air emissions by shutting down the plant. As you are aware, the landfill will continue to produce gas which will be wasted through flaring if we are unable to operate. At this time, we do not expect any excess emissions from operating with a variance. The turbines are very clean burning. During last year's emissions testing, NOx emissions were about 0.7 pounds per hour. CO was about 0.2 pounds per hour, and VOCs were about 0.1 pounds per hour for both engines. The TSA flare has similarly low emission rates. During 2018 testing, NOx was 0.2 pounds per hour, CO was 0 pounds per hour, and VOC emissions were 0.04 pounds per hour. I can't speak to the landfill's flare emission rates, but I think once you get down below 1 pound per hour, the difference will become negligible over such a short period of time for criteria pollutants. In regards to finding 4, we have considered cutting back operations, but there appears to be no benefit in doing so. As you're aware, the amount of gas the landfill produces is fixed over short periods of time, and curtailing our operations will not result in a reduction of landfill gas that will have to be burned. It will simply affect how it is burned. We would certainly rather see it be used to make electricity than wasted by being burned in a flare. Finding number 5, as previously stated, we do not expect this variance to result in any excess emissions. We will continue to operate the facility in an environmentally conscious manner in compliance with all other regulatory requirements during the variance period. And finally, finding number 6, during the variance period, we will continue to monitor operating parameters necessary to calculate emissions from the plant, including fuel flow rates and data from the NOx SEMS on the turbines. If requested by the board, we will report emissions from the plant to the best of our ability and in accordance with the schedule established by the board during the variance period. Thank you.
Thank you. Ms. Reichart, questions?
Thank you. As for excess emissions, if the source test reveals that you've exceeded one of the limits, you do understand that you would then have to go back and calculate excess emissions for the period of the variance.
Yes, ma'am.
Okay. That's all the questions I have.
You told us what the emissions were from the 2018 source test. Do you know how far below the limits that was?
I can provide you with summary copies of our source test results, or would you like
Is
me
that
to?
from 2018?
This is
or
from 2018.
I think it's
I can
fine.
just
You
explain.
read to us 0.7, 0.2, and 0.1 NOx, CO, and VOC pounds per hour for the engines. I'm just wondering if you happen to know what the limits are.
Yeah, so I don't believe there's a pounds per hour limit for those pollutants, but there are pounds per day limits. And just for example, in 2018, turbine 1 was 16 pounds per day of NOx. The limit is 126 pounds per day of NOx.
Thank you.
Should I keep going?
Sure,
Okay.
if you have more to add to that.
Sure, and CO for turbine 1 was 5 pounds per day, and the limit is 374 pounds per day. VOCs for turbine 1 were 2.3 pounds per day in 2018, and the limit is 12.5 pounds per day.
So just to summarize that, they were significantly below the limit.
Yes, ma'am.
Okay.
Turbine 2 is roughly the same as turbine 1.
And do you happen to know whether the engine 2 and the flares passed the source test this year?
No, ma'am, there's laboratory results that we have to wait for.
Okay. And even, I just wanted to make sure that this is correct, but your understanding of Rule 1150.1 and of your permit conditions is that even if you just temporarily shut down the turbine, that hasn't been tested and shut everything down in terms of, for reporting purposes, you would still be in violation. Is that correct?
That is correct.
Okay.
Yeah.
So shutting down does not put you in compliance with rules?
No, ma'am.
Okay. Also, I just wanted to make sure, when you went through each of the findings, you mentioned 1150.1, but you did not mention the permits. You are only, as far as the permits are concerned, you're only now asking for relief, tell me if I'm correct, from the permit condition 20 with regard to annual testing for engine number 1.
Yes, ma'am.
Okay, and just so we're clear, that is that G25211?
That's correct.
Okay. And you said you're a Title V?
Yes, ma'am.
Okay, so you'll need, you would need relief also from 203B, which is the rule that requires all facilities in the district to comply with their permit requirements, correct?
That's correct.
And then, I can't recall which is, you're not, are you reclaim as well?
No, ma'am.
Okay, should say in here, but you are Title V, okay, so that's 3,000, is that 3,000? 3002C1, okay. So you'll need both from Title V, which requires that you comply with all permit conditions in their Title V permit, as well as 203B for just your facility permit, correct?
That's correct.
Okay, thank you, those are my questions. Anyone else have questions? Ms. Byrd?
Just to clarify, these engines are always run together? They're not one and first run and
They can be run separately.
okay, so it's possible that there is not always this amount of emissions? Would that be correct, if you're only running one engine? Because let me back up. Each engine is producing the 16 pounds of NOx and the 5 pounds of CO and the 2.3 of VOC, approximately, you said, right?
Yes, ma'am. Roughly.
And so if you're only occasionally running one or the other, then it wouldn't be double this all the time. So it'd be even less maybe than.
Yes, ma'am. If we're only running one engine, then it would be just one engine's worth of emissions. We do try and run both as much as possible because there's
okay.
enough fuel.
There is enough fuel.
that.
Okay, so it's, okay, I just wanted to make sure I had that right. And then the shutting down of the engine at $10,000, 10,000 per day, is that based on shutting down just this engine that has to pass, or is that based on shutting down both the engines?
That's based on shutting down both engines.
Okay, thank you.
Mr. Balagopalan?
Yes, Mr. McCallum. So do you know if both engines were not operating, is the flare designed to handle the capacity that would have gone to the engines, to the turbines?
The landfill's flare is designed to handle.
Not the one that you,
Our TSA flare is quite small compared to the landfill flares.
okay. So they would have to burn everything over there.
Yes, sir.
Okay. Now, you have some NOx
Yes, sir.
for each of those, and they're continuously monitoring the NOx rate and so forth, and you're recording that.
Yes, sir.
Both for NOx and CO, or
Just for CO. Or, I'm sorry, just for NOx.
just for NOx? Okay. All right, thank you.
Any other questions? Senator?
Have you read the proposed variance conditions?
Yes, sir.
And you can discuss two with confidence that it can happen? Even though the wind is the determining factor.
I.
Those deadlines.
For number one, we have installed scaffolding on turbine number one, so wind should no longer be an issue. I don't know if there's going to be lightning that day or any number of things could go wrong that would delay testing. I certainly hope that doesn't happen. I certainly
I
hope.
know hoping is one thing.
Okay.
What could likely happen that would, if the wind is not a factor anymore, then no problem.
A thunderstorm, if there's a problem with the landfill's well field where all of a sudden we have high oxygen in our gas that we won't be able to run, there's a lot of things that could go
Do you
wrong.
ever have high oxygen in your gas before?
I don't know about this facility, but at others, yes, it's happened when a well is run over or fills up with
I
water.
mean, with regards to item number 2 here, I was thinking you might use a footnote in case if the wind flow is below 25 miles per hour, then you would meet that schedule, a footnote. But if it's not, you can't.
Can you explain what you mean by a footnote?
Or just a notation.
Either there's a a variance condition, or there isn't one.
Well, the point is that it's a condition with one minor exception. You got to include that. You can only meet this condition in 2 if the wind is below 25 miles per hour. That's already been explained in the petition. So there's nothing wrong with saying, yes, we can adopt and number 2 would be applicable unless the wind flow is exceed 25 miles per hour. If you don't want to do it, fine by me, but that could be a reason why you don't meet that deadline of July 19th.
Just so we're clear, the July 19th is for engine number 1, and the wind flow is not a factor on that because of the scaffolding. The July 7th date in proposed condition number 2 is for engines 2 and the turbine, which were already tested. So there should be no issue with wind.
You don't really need that in there then.
We do, because they have not yet done the reporting, so they'll need a variance.
So can you meet your June 4th deadline if there's a wind flow of 25 miles per hour?
If it's just wind, we will be able to test that day because we have installed scaffolding.
Oh, very
on
good.
that
Okay,
engine.
thank you.
Any other questions? Mr. Belagopalan?
Is that a temporary scaffolding, or is that going to be permanent over there? Do you know?
That's a temporary scaffolding.
Scaffolding. So bearing any other, you said the test may not occur on the 4th if there's some problems with the quality of the gas coming in.
I was just speculating. There could be a million reasons why the test could not go forward.
So do you see a need to have some flexibility on that date?
Yes, sir, that would be helpful if you can offer that.
Okay, thank you.
I wouldn't be apt to offer flexibility unless there were testing flexibility. And so we don't want to be in the situation where we offer flexibility or don't, and we're back here again because there was lightning strikes or oxygen in the fuel. So we can discuss that, but I don't know if Ms. Reichard, if you were so inclined as to consider a change in your proposed conditions.
Do you want me to address that now?
Yes.
I think that the circumstances that petitioner is describing are very unlikely outlier events. I understand why you're naming them, because you want to be thorough and accurate in your answers. But, a lightning strike, I think that's, to be fair, the weather this year has been very unpredictable and unusual. So if the board wants me to consult with staff and talk about some other option, some kind of an if-then, but I don't know if we want to list out all these potential things. I mean, the wind, which was the concern before, is no longer a concern. So if we're talking about lightning strikes or some malfunction or something like that, I don't know if it's likely enough for us to modify the condition.
Okay, well, let me ask some questions, Mr. McClellan. what is the likelihood that, I mean, have you, for example, let's start with lightning or other adverse weather, have you had any of that at this location other than wind in the past?
No, ma'am. To my knowledge, wind has been the only issue.
Okay, and so testing has gone forward every year since 2011, with the exception of this time?
I have only been with Amoresco since 2015. Since then, testing has gone forward without issue.
Okay, and is it that you scheduled the test to be on June 4th with your testing company? I forget the name of it, Eros, is that
Yes, ma'am, Arrows.
Eros? Is that, you scheduled it to be June 4th?
Correct.
Do they have availability should the test not be able to go forward on June 4th?
When we originally tried to schedule without swapping with another one of our facilities, they told us that their availability started in July. So I think if they are unable to test on June 4th, then we're going to have to look at other testing companies to get it done.
All right, we'll talk in deliberation, thank you. We'll talk in deliberation amongst the board members, but I think this is an interim variance, and I think we should go with the testing date. And if there's an issue, we'll be back here for a short variance hearing.
Madam Chair, I think it's important to the petitioner that a situation should occur which is beyond his control, where the testing could not be complied with as specified, then they should just notify the district.
Well, they'll be back here. This is an interim variance we're considering, so petitioner will be back for a short variance. Should anything occur, that would be the time to let the board know it did not occur and why. And the board can make a decision at that time whether the findings support a different short variance.
They would not be in compliance, that's what you're saying. Okay.
Yeah, I think that would be the time to address it, as opposed to prospectively, just as the rules, Rule 1150.1 doesn't have any footnotes or exemptions for weather.
If I may just offer piece of consideration for the board, if you want to take judicial/board notice. I have consulted weather.com and for Castaic, and on Saturday and Sunday, June 1st and 2nd, there is a 10% chance of rain, but June 3rd and June 4th is sunny in the 80s with 0% chance of rain. Just going to throw that out there.
So noticed.
May have an effect.
Let me just ask, Mr. McClellan, can the testing go forward in rain?
Yes, ma'am.
Okay, thank you. Mr. Balagopalan?
You said they'll be there June 3rd, right? And the
Yes,
3rd and the
sir.
4th, so the pre-testing, I mean, the setup and everything
That's
on
correct.
the 3rd and do the actual testing on the 4th.
That's correct.
Okay. And you have a commitment from them that they will reschedule their test at the other facility and be here on those dates?
We have hired another company to test at the other facility.
Oh, I see, okay, thank you.
Any other questions for Mr. McClellan? Okay, thank you, Mr. McClellan. Ms. Reichart, did you wish to introduce any witnesses?
I did not. I did bring engineers if there were remaining questions by the board, so if there are any outstanding questions.
Board members, any questions for any district witness? Do you want to indicate to Ms. Reichart what question you have so she can determine?
Yeah,
which-
it's just whether the district is going to amend the permit to reflect what's in the rule, because there's, that's,
Testify? Okay. The district calls Angela Shibata. Could you please state and spell your name for the record?
My name is Angela Shibata. That is ANGELASHIBATA.
And what is your position here at the district?
I'm a senior air quality engineer.
And did you take the oath this morning?
Yes, I did.
And can you answer the question posed by the board, please?
Yes, during the next Title V revision for this facility permit, we plan on updating that permit condition to, at the very least, indicate that Rule 1150.1 needs to be adhered to for the source testing condition.
and when is that date, Ms. Shibata?
I'm not certain. We have some applications open with this facility, so when those are processed, we'll include this change as well.
Oh, okay, thank you. So you're not waiting for the renewal of the Title V permit to do that?
Correct.
Okay, thank you.
Any other questions for Mr. Shabata? Any other questions for Mr. Shabata? Mr. McClelland, any questions on that?
No, ma'am.
Okay. Okay, before I close the hearing, hearing board members, any other questions you wish to have answered by, no, by district staff? Okay, thank you very much. Thank you, Ms. Shabata. I know, Mr. McClelland, you've probably gone over these a million times. Would you like to make any closing statement at this time?
No, ma'am.
Ms. Reichart, closing statement?
Thank you. Subject to compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
Thank you. Board members, I do believe we can make the interim variance findings. We already talked about the specific, but I'll be more specific. I think that Mr. McClelland was in his opening, and that was a better way to put it. Right now, the petitioner is in violation of several rules and one permit condition. For engine 1, permit number G25211, the petitioner is in violation of 203B 3002C1 with regard to condition number 20 of its permit, and that is for annual testing, having missed that testing date due to high wind conditions. And also for engine 1 of Rule 1150.1 D1C Romanet 1 with regard also to testing. And for both turbines, engines 1 and 2, and the flares, in violation of 1150.1 F2A with regard to reporting of source test results. I believe that just as we were able to find good cause, that this was due to conditions beyond reasonable control. In terms of engine 1 not being tested, that was due to high wind conditions that were not foreseeable because they happened once before and did not prohibit testing. So now they've taken and they've guarded against it for retesting with scaffolding, which is a really good step to take. With regard to the 1150.1, both the engine 1 testing date and the source test results, we already established as part of beyond reasonable control, as part of good cause, that we believe it was an honest mistake due to not being very clear in the permit, and as Ms. Shabata testified, the district does in fact plan to update that Title V permit at some point in the future in order to clarify. And requiring compliance would result in an unreasonable taking of property. We heard $10,000 per day. Were they not able to operate the engines? However, that's not, that would put them in compliance anyway. But regardless, if they were to shut down, they would have that loss and certainly would be open to fines, and that would be without a corresponding benefit in reducing air contaminants. It's expected because it's just a testing issue and reporting issue. It's expected that there are no excess emissions, as Ms. Reichart questioned and pointed out through questioning with Mr. McClellan. It could potentially be that once engine 1 is tested, it is above the limit. However, I do believe that to be unlikely, given how far below the limits engine 1 was in 2018 when it was tested, and these are fairly new, relatively newer engines. So I can make finding number 3 that taking in terms of losses would be without a corresponding benefit in reducing air contaminants. Curtailment is not an option. Shut down, they're still in violation. So they can't do that in lieu of obtaining a variance. Reducing excess emissions to the maximum extent feasible, again, not really applicable because we don't expect any excess emissions. And the use of the turbines, which are relatively clean burning, is the best use. It's better than flaring. And monitoring, we heard testimony with regard to monitoring in terms of fuel usage, although that's not part of the conditions, and I don't know. It's part of the permit. Thank you. It's part of the permit. And so that will all be monitored, although excess emissions, again, are not anticipated. Anyone else wish to have? Ms. Byrd?
I would agree with your findings. And I think that in this situation with the landfill and the gases, there will be landfill gas, whether it's taken care of here or if it's taken care of at the landfill. And I think for me that's significant. We don't know what the landfill flare emissions are like, but we do know that these are very low emissions. And I think that's significant. The gas is going to be burned. This way it's used for energy as well as there's a low emission rate. And I think for that, it confirms for me all the other findings.
Thank you. Any other thoughts? Mr. Balagopalan?
Yeah, I have to agree with Ms. Bird. I think even though the flare numbers here at this where they're burning it shows very low emissions. In fact, it's cleaner than the turbine, but I think Mr. McCallum testified that they don't have the capacity to burn completely here. It'll be done at the landfill, and we don't know if that's cleaner or not. And again, as said, it would be a waste of resource because the gas has been burned to generate electricity, and so I think on that basis, on that there's no benefit in curtailing the operation at this facility.
Senator, do you have any thoughts?
The landfill is there, it's not going away. And the gas is being generated by that source. And so therefore, it can only migrate into the atmosphere, cause more problems if you're not allowed to burn it, flare it, excavate it, use it for energy. So I would say that's the way to go, and I would support the motion.
Thank you. Any other thoughts? Okay, I'm going to turn now to the parties. This case has been set for short variance hearing June 26th. The board has some issues with scheduling on that day. I was going to suggest July 16th as a short variance, but given the conditions of the variance, what I'd like to do, if the parties are available, is to set the short variance for July 19th. And it could either be that there's full compliance or there is a hearing on that day. I'll ask Mr. McClelland, are you available on that date?
Yes, ma'am.
Okay. Ms. Reichart? No.
No, but that's a Friday.
I'm sorry. It is a Friday? Okay. Then we'll make it. Let me look again at the red book. That's why I should consult the red book. I'm like, okay, I thought that the 16th. Okay. Then let's make it for the 23rd of July. Is that,
Yes, that's acceptable.
and for petitioner?
Yes, ma'am.
Okay. Okay. So then with that, I'm going to make a motion. in the matter of Amoresco Chiquita Energy LLC, case number 6143-1. I move that we grant an interim variance that would begin today and would go for 90 days or until this matter can be heard for a short variance, which is currently scheduled on July 23rd, 2019, whichever occurs first. It is for the facility at 29201 Henry Mayo Drive in Castaic, 91384. And it is for the following engines and flare and from the following rules. For engine 1, permit number G25211, it would be from rules 203B, 3002C1 with regard to permit condition number 20 with regard to the requirement of annual testing. It is also for engines and for engine 1 from 1150.1 D1CI. And for engines 1, 2, and the flares, which are listed with their permit numbers on page 3, number 6 of the permit, from 1150.1 F2A with regard to reporting requirements. I further move that we incorporate Exhibit A, which are the proposed variance conditions. And I have no changes. Is there a second? Senator seconds. Any discussion on the motion? Seeing none, Mr. Balagopalan, how do you vote?
Yes.
Ms. Byrd, how do you vote?
Yes.
Senator, how do you vote? I vote yes. Motion passes 4-0. I'm sorry. Oh, thank you. There are no excess emissions anticipated, although that could change, hopefully not. Okay, any other discussion? Okay, thank you. Thank you, and good luck, and we may or may not see you on the 23rd. Any other business, board members? Okay, seeing none, we are adjourned.